Good evening, everybody. I'm your host, the Supreme Litigant. I'd like to welcome all y'all back to Smart Low TV. Before I begin, y'all already know the routine. If you haven't already, please go ahead and subscribe to my channel. Go ahead and pound that subscription button and hit that like button for me. And I'll give y'all a second to do that before I begin. All right, y'all. So I'm gonna jump right into this. I was doing some research on for remedies at law. Uh, and out of nowhere, I just saw this case, which is it's really unrelated. But this is an Alaska case. And in this case, they are providing you with the distinctions between um, a counselor and an attorney. So what I'm trying to say is, I think a lawyer would not be a correct term to to distinguish from an attorney based on this case. But y'all want to know what's so funny about this, man? This is going to be a long video. It's not going to be too long, but it's going to be long. The fact that you have to go and do all of this research just to find out the definition for one word with these people is crazy. Let me go ahead and start this video. I don't want to bore y'all. So I'm gonna go ahead and read some of it. There's the I don't know if I showed y'all the case citation. That's the case citation right there. So y'all can go and look it up. This guy, he made a pretty good argument if you ask me. But anyway, petitioner, I'm gonna call him Crane, is currently charged with driving under the influence, and I'm not gonna read any of these statutes or nothing like that unless I have to, and refusal to take a breath test. As he is waiting trial in the district court, in his petition, Crane asserts correctly that he is entitled to the assistance of counsel in defending himself against these charges. But Crane insists that he cannot obtain the assistance of counsel because there are no counselors at law in Alaska. I wonder if he did this by himself. This is very interesting, y'all. Now, I'm not like when I first started reading this, I thought they were going to just start obfuscating and just calling this man crazy and saying this is sovereign citizen BS and all that. I really thought they was going to do that, but they didn't even do that. They actually dug down and did the research, and they provided you with the research in this case. Crane contends that there is a legal distinction between counselors at law and attorneys, and that there are no counselors at law in Alaska because the Alaska Bar Association and the Alaska Supreme Court only license attorneys. Crane further asserts that because he is unable to obtain the assistance of a counselor at law, the courts of Alaska have no jurisdiction over him. And he's citing this case in support of his authority because they can't try you without an attorney unless you knowingly, let me rephrase that. I'm going to stop using that word. They can't try you without counsel unless you knowingly, intelligently, and voluntarily waive that right. They have no jurisdiction over you. And when they do that, they violate due process, and you can get a trial de novo. You can get a whole new trial when they do that, just to let y'all know. Holding that a deprivation of the right to counsel is equivalent to lack of jurisdiction. It's a jurisdictional prerequisite. In order for them to have jurisdiction over you, they need you to have a counsel. You need to have counsel in order for them to have jurisdiction over you. That's why they're always trying to appoint you one of their counselors, so to speak. But anyway, I don't call them counselors; they're attorneys. Back to the case. In the alternative, even assuming that the attorneys properly licensed by the Alaska Bar Association and the Alaska Supreme Court qualifies as counselors at law, Crane argues that the Bar Association and the Supreme Court lost their power to license attorneys in 1976. Crane bases his argument on the fact that in 1976, the Alaska legislature repealed a statute that specified the procedure for admission to the practice of law and failed to enact an equivalent statute in its place. As we explain here, the common law did, in fact, distinguish between attorneys and counselors at law. Do y'all see that? Crazy, right? Crazy. It's going to get good, y'all. But this distinction no longer exists under Alaska law. Instead, attorneys perform both functions. So what were the differences in the functions? They're going to discuss that. We therefore reject Crane's assertion that there are no counselors at law in Alaska. Let me go back up. And it is true that in 1976, the legislature repealed the statute that specified the procedure for admissions to practice of law in this state. Notice that, you see that? Notice the word state is lowercase. However, in the same 1976 session, the legislature gave rulemaking authority to the Board of Governors of the Alaska. That's an administrative agency. So what they did was they delegated their legislative authority, which they had no authority to do that because that power does not ultimately belongs to them. It belongs to the people. So I think that was an unlawful delegation of authority, of legislative authority. But anyway, the legislature gave rulemaking authority to the Board of Governors of the Alaska Bar Association so that the admission procedure could be specified by court rule, which has been done. We therefore conclude that even after the legislature's amendments of 1976, the Board of Governors and the Alaska Supreme Court properly continue to certify and admit applicants to the practice of law. Crane is charged with driving while under the influence and refusing to take a breath test. Okay, we're going to skip that. This is where it gets good at. Now, he's talking to the court. The court is a fiction, by the way. The court. Notice they're not the judge's name. It doesn't say the judge's name. He's talking to the court, which is a fiction. But anyway, would you define for us in 25 words or less what assistance of counsel is if it's not a lawyer? Crane, to be truthful with you, I don't know what the law is on this point, and I don't know what the definition of assistance of counsel is. That's why I need the assistance of counsel. This guy's good, y'all. I wish I knew who this was. Hearing this, Judge Estelle tried to assure Crane that counsel meant the same thing as a lawyer. The court, a lawyer is someone that is licensed to practice law in the state of Alaska. Someone who has been to college, law school, and has passed the bar exam. That's a lawyer. That's the assistance of counsel. So do you intend to hire a lawyer? This judge is lying, by the way. But he's giving the, I'm guessing that's a woman. She's giving the definition under some statute within that state of what an attorney or a lawyer is, in my opinion. Crane, no, I'm trying to find assistance of counsel who will assist me here, not represent me. That's pretty good right there. I'm no indigent, and I do not want anybody to appoint me a lawyer, but I want assistance of counsel to assist me, and that's it. I'm not, no more debate. The court, but assistance of counsel means lawyer. Crane, I have it right here. Assistance of counsel under the Sixth Amendment. It does not say attorney. Now let me stop right there. The people who I'm not sure who drafted the Constitution, but they had to be counsels or law, whatever you want to call it. They had to have some type of sense to know what they were doing. And they did not use that word, and I'm convinced that they didn't use that word on purpose. Back to what I was talking about. No more debate. I do not wish to discuss this here, sir. This is the book I'm reading, and it says that I have a right under the Sixth Amendment to assistance of counsel, and it does not say attorney or lawyer. After Judge Estelle heard the explanation of Crane's position, he told Crane, so that's a guy, the court, you can hire a lawyer or not hire a lawyer, but you need to be on notice that assistance of counsel in this state of Alaska means somebody who is licensed to practice law. That's what assistance of counsel mean in this state. Excuse me. You seek to draw a distinction between assistance of counsel and a lawyer and an attorney or a counselor at law or whatever else you want to call a lawyer. But it makes no difference legally. Assistance of counsel, counselor at law, attorney at law, lawyer, they're all the same thing. So you can represent yourself or you can hire somebody to represent you. But if you do not hire a lawyer, you're going to be representing yourself, and you'll be held to the same rules in presenting your case as a lawyer. as lawyers are. Crane now seeks appellate review of judge's stale ruling. He renews his argument that attorneys are not counsel for the purpose of the right to the assistance of counsel under the Sixth Amendment to the United States Constitution. In addition, Crane argues in the alternative that even if properly admitted, attorney would not qualify as counsel for these purposes. There have been no properly admitted attorneys in Alaska for the past 30 years because in 1976, the Alaska legislature withdrew the Alaska Bar Association and the Alaska Supreme Court's right to certify and admit applicants to practice law. Crane's argument that he is entitled to the assistance of counsel at law, and that while there are many, let me see, and that while there may be attorneys at law in Alaska, there are no counselors at law. The terms attorney and counselor originally did have differing meanings. Y'all pay attention. Just pay attention. This is where they're going to start breaking this stuff down. Some of y'all already may know this stuff. But I thought this was a really, really good case. I didn't even read all of it. And I'm not going to read all of it in this video. I would advise you to, though. Both words come from Old French, the language spoken by the Normans, who conquered England in the 11th century. See how they're going back in time, telling y'all what's going on? The word attorney first appeared in Anglo-French writing in the early 1300s. At that time, it was written attorney or attorney, attorney or whatever, something like that. This word is the past participle in English, the ed form of the verb attorner or attorner. The verb attorner literally means to turn to, in the sense of turning to someone for aid or assistance. It then came to mean to turn over to, in the sense of entrusting one's affairs to another person. Thus, by the time the word showed up in Anglo-French writing, attorney or attorney meant to assign or appoint someone to act as your agent or representative for any purpose, not just lawsuits. And the word attorney, attorney, whatever you say, it looks like seems like it's some type of French word, if I'm not mistaken. And the word attorney meant the person who was assigned or appointed. And then they have a footnote in here. Let's see. We still use the word attorney in the broad sense when we speak of giving someone a power of attorney to transact business or make decisions on our behalf. And the person to whom we give a power of attorney is called an attorney, although we use the phrase attorney in fact, because nowadays the word attorney standing by itself means a legal profession. Okay. In early English law, a private attorney was someone who was appointed, usually hired for pay, to act for another person in any sort of business, including but not limited to legal affairs. On the other hand, a public attorney or an attorney at law was a person who was licensed to represent people in courts, but not represent in the full sense that we would understand today. That's interesting. An attorney at law could investigate and prepare cases for court and could attend court proceedings as the personal representative of the person whose interests were at stake, but the attorney could not actually plead the case, i.e., could not participate as an advocate at the hearing or trial. That job was assigned to the counselor. So this is who this guy is asking for. Or counsel, the legal professional, now known as a barrister in England. This is getting good. The word counsel used as a noun rather than a verb comes from the Old French counsel, which meant a plan or opinion. Thus, a counselor was a person who formatted a plan or rendered an opinion. I can agree with that. Again, we still use the word counselor in the broader sense, but the word also came to mean a professional legal advocate, a person who was versed in the law and whose profession was to plead cases in the courts. So I'm not a lawyer. I'm a counselor. So you're not a lawyer, you're a counselor. So this is why they say the right to counsel. So obviously, whoever drafted the Constitution intentionally used the word the right to counsel to omit attorneys from trying cases in there. It seems like that's what happened to me. The terms counselor and counselor, the terms counselor and counsel, used in this sense, first appear in Anglo-French writing in the late 14th century. The common law distinction between attorney and counsel is described by William Blackstone in his commentaries on the laws of England, first edition, blah, blah, blah. There it goes. I need to find that book. I need to see if I can find that and read that. And I'll try to do a video on that for y'all. It is also usual in the superior courts to have attorneys and advocates or counsel as assistants. By the way, that footnote right here is telling you where you can find this stuff. The complete text of the first edition of William Blackstone's commentaries is available online from the Yale University Law School's Avalon Project. I wonder, is it free? I'm going to try to find that and see if I can read that. An attorney at law is one who is, well, I probably don't need to read that. Y'all already know that. I'm gonna skip down. I'm gonna let y'all. I think I read the most of the good parts. So I don't want to bore y'all with all of that. But I am. Which one is it? It was something. I think it was. Was it down here? Yeah, it was a little bit more. Um, this is kind of long. I don't really want to bore y'all because, well, they do mention some more cases that also draws the distinction between them. So I might just read y'all that part and then the end of the passage that I wanted. So I'm gonna start back right here. Sorry about that, y'all. In the 18th and 19th centuries, the word attorney became a term of contempt in England. So much so that Parliament abolished the term in the judicial in the Judicature Act of 1873. Thus, in England, the people who performs the traditional roles of attorneys at law are now known as solicitors. So I wonder why did they have why were they so contempt uh, with that word in England? That's very interesting. These are some footnotes right here. Y'all can read those if y'all want. I'm gonna stop right there and let you read them if you want to, and I'm gonna scroll down. However, the term attorney survived in America. Originally, in American law, the word attorney had the same limited meaning as under the English common law, personal representative. This older meaning is illustrated in an 1833 opinion of the Pennsylvania Supreme Court, Mercer versus Watson. So if you're in Pennsylvania, here's the case. You can go and read that. Let's see. Parties are technically and properly said to appear in suits by attorney and not by counsel. Counselor or counselors are terms familiar to the law. The province of these professions is not simply to appear in actions as the personal representative of the party. Rather, it is to conduct the suit by their advice and advocacy through all of its progress. I'm sorry, and in the difficult emergencies nowadays, we would say developments or contingencies of a trial by jury and of arguments before the court. Uh, I'm a, um, I'm gonna start back right here. Let me see if I gotta see if I'm wrapping this up because I don't want to read too much. Yeah. Okay, so I'm gonna start back right here. No, right here. I'm sorry. I'm gonna start back right here, and then I'm gonna go down to probably about 2 to 3 more paragraphs, and I'm gonna stop there, and that'll be the end of this video. Nevertheless, even at the time of Mercer versus Watson, the line between attorney and counselor were blurring in the American legal practice because the same legal professionals normally performed both functions. As indicated by the passage from Blackstone and as indicated by the Pennsylvania's court's opinion in Mercer versus Watson, both attorneys and counsels at law were regulated and licensed by the government. Moreover, the opinion in Mercer versus Watson shows that by the 1830s, American law had already departed from the English rule described in Mercer versus Watson, the rule that the office of attorney was completely separate from the office of counsel. So that was a rule in England that they were separate offices, but they departed from it here, which they can do that because they're sovereign. But I just wanted to, I want to point this stuff out to y'all. The rule that the office of attorney was completely separate from the office of counselor, and that no counselor or barrister could take on the role of attorney without first resigning his office, asking to be disbarred. Let me read that again. And that no counselor or barrister. Okay. I see what they're saying now. Rather, in America, or at least in Pennsylvania in 1833, counsels are always attorneys, and under our rules, members of the bar are admitted to practice either as attorneys or counselors. Let's see. In fact, the Pennsylvania court noted that the formal procedures that distinguished attorneys from counselors were breaking down and falling into disuse. The court discussed the fact that under Pennsylvania law, a counselor who was also functioning as the attorney in a case, that is, a counselor whose client was absent from court, so that the counselor was performing the double duty of legal advocate and personal representative. So basically, if I understand this correctly, an attorney is just a personal representative that was delegated certain duties to, like he was delegated to handle personal affairs, basically. Um, and counselor, they would actually argue the cases before the court. It seems like that's what they're saying in here. If I'm wrong, y'all let me know. But it seems like that is exactly what they're saying here. I'm gonna start back right here. The court discussed the fact that under Pennsylvania law, a counselor who was also functioning as the attorney in a case, that is, a counselor whose client was absent from court, so that the counselor was performing the double duty of legal advocate and personal representative of the client, was supposed to file a separate document, a warrant of attorney, what we would now call a power of attorney. Okay. Remember, it doesn't matter what they call it. It matters the its substance over form. It doesn't matter the title of the document. It's always substance over form. That attested to the fact that their client had appointed them to be their attorney. In the narrow sense of the word, despite the existence of this law, the Pennsylvania court acknowledged that it is not the practice and never has been in this state for counselors at law to file warrants of attorney, and yet they still receive their fees and speak for their clients without their authority ever being questioned. That's interesting. The merging of the two roles of counselor and attorney continued in America to the point where today many legal professionals would be unable to correctly describe the common law distinction between counselor and attorney at law unless they performed legal research of the sort described above. But for purposes of resolving the arguments raised by Crane in this position, the important thing is that as a matter of Alaska law, the term attorney now encompasses both meanings. I'm going to stop right there. This is a really good case. I haven't read it all yet, but I think they really go down into the details of it. I think this is a really good case. If y'all want this case, you can go and read it for yourself. I think this was really a really good breakdown of it. I'm not sure who this so-called judge was or whatever, but it seems like it was a man, and he did a really good job. Let me see. Decrying improper persona Wallace for the petitioner. He did a really good job explaining that. Really good job. So this is the case citation again. If y'all want it, I'm gonna highlight it for you just so you'll see. This is a good case. I would advise y'all to go and read this case. Really good case. That'll be the end of this video. Let me see how long it is. Look, it's 24 minutes. I thought it was gonna be longer than that. Lock the door. That'll be the end of this video. Before I end it, if you haven't already, please go ahead and like and subscribe to my channel. The Supreme Litigant is out. Peace.